In contract law, a non-compete clause agrees not to enter into or start a similar profession or trade in competition against another party. Some courts refer to these as restrictive covenants. As a contract provision, a CNC is bound by traditional contract requirements including the consideration doctrine. The use of such clauses is premised on the possibility that upon their termination or resignation, an employee might begin working for a competitor or start a business and gain competitive advantage by exploiting confidential information about their former employers, operations or trade secrets, or sensitive information such as customer, client lists, business practices, upcoming products, and marketing plans. However, an overbroad CNC may prevent an employee from working elsewhere at all. English common law originally held any such constraint to be unenforceable under the public policy doctrine. Contemporary case law permits exceptions, but generally will only enforce CNCs to the extent necessary to protect the employer. Most jurisdictions in which such contracts have been examined by the courts have deemed CNCs to be legally binding so long as the clause contains reasonable limitations as to the geographical area and time period in which an employee of a company may not compete. The extent to which non-compete clauses are legally allowed varies per jurisdiction. For example, the state of California in the United States invalidates non-compete clauses for all but equity stakeholders in the sale of business interests. As far back as Dyer's case in 1414, English common law chose not to enforce non-compete agreements because of their nature as restraints on trade. That ban remained unchanged until 1621, when a restriction that was limited to a specific geographic location was found to be an enforceable exception to the previously absolute rule. Almost 100 years later, the exception became the rule with the 1711 watershed case of Mitchell v. Reynolds, which established the modern framework for the analysis of the enforceability of non-compete agreements. A 2021 study of the U.S. healthcare sector from 1996 to 2007 found that non-compete agreements this sector led to higher prices for physicians, smaller medical practices and greater medical firm concentration. A 2021 study found that non-compete agreements for low-wage workers have been shown to lower wages. A study determined that the 2008 Oregon ban on non-compete agreements for workers paid by the hour increased hourly wages by 2% to 3% on average. The study also showed that the Oregon ban on non-compete agreements for low-wage workers improved average occupational status in Oregon, raised job-to-job mobility, and increased the proportion of salaried workers without affecting hours worked. Canadian courts will enforce non-competition and non-solicitation agreements. However, the agreement must be limited in time frame, business scope, and geographic scope to what is reasonably required to protect the company's proprietary rights, such as confidential marketing information or client relations, and the scope of the agreement must be unambiguously defined. The 2009 Supreme Court of Canada case Chaffrong v. KRG Insurance Brokers Inc. 2009 SCC 6 held a non-compete agreement to be invalid due to the term Metropolitan City of Vancouver not being legally defined. The 2000 Ontario Court of Appeals case Leon v. Moultrie established a general preference towards non-solicitation over non-competition agreements, regarding the latter as much more drastic weapons, and held a non-competition agreement to be invalid when a non-solicitation agreement would have been sufficient to protect the company's interests. For an employee who has the obligation to protect the employer's confidentiality and trade secrets, the employer and the employee may agree on the inclusion of non-competition clauses in the employment contract or a separate non-disclosure agreement, in the event that the employment contract has been terminated or has expired. During the agreed non-competition period, the employer shall pay compensation to the employee on a monthly basis. If the employee breaches the non-competition agreement, he/she shall pay damages to the employer as agreed. The personnel subject to non-competition agreement shall be limited to the employer's senior management, senior technicians and other personnel with a confidentiality obligation. The scope, area and term of the non-competition agreement shall be agreed by both the employer and the employee, and such agreement must not violate the laws and regulations. Upon termination or expiration of the employment contract, the term of non-competition for any of the persons is mentioned in the preceding clause to work in any other employer producing or engaging in products of the same category or engaging in business of the same category as this employer shall not exceed 2 years. If the parties have reached an agreement on non-compete